Welcome. This is Stein Whatley from Stein Whatley Astorino, Louisville's personal injury law firm. I've got my partner, Rob Astorino, with me. Today, we're going to answer a question that we get often. I'm sure a lot of attorneys get this question. You may have this question on your mind as well. How long does a personal injury case take? I can give you the general timeline as investigation, treatment, negotiation, lawsuit, trial, appeal maybe. Let's talk about the delays that happen on this and just built-in time necessary for each one of those stages.
Sure. And, like any good legal answer, the answer is it depends.
Right.
So, video over. Right. That is ultimately your answer. But we will be giving you a little bit more satisfying information than that. Yeah. There are some general timelines involved with the steps of this, an average personal injury case, and we're going to talk to you a little bit about that.
All right. Well, let's start. The initial stage is investigation. Oftentimes, I've heard people refer to this sort of like the military does, like hurry up and wait. So in our situation as a firm, we send out, as soon as we get a client that comes in and retains us, we send out a lot of requests to a lot of different third parties for information, and we're putting them on notice. And then there's not much for us to do at that moment because now we've got to wait either to get information back or we are waiting for our client to treat, that sort of thing. Maybe discuss that.
Yeah, we'll talk about treatment here in a minute, but if you get into a personal injury situation, car wreck, truck wreck, fall down injury situation, or if we get a new client who comes into the office, like John said, we send certain pieces of information out. One of those things we send out is medical records requests. And generally, if we send a medical records request to get information we need to prove our client's injuries and damages, the providers that have that information have up to 30 days to respond. Now, of course, that doesn't always mean that they respond within the 30 days. Some providers require follow-up.
And then some providers, they're allowed by HIPAA rules to get another 30 days.
Yeah, very
they
few.
They request it, but
very few providers do that correctly, right. But some of them just take the 60 days, and there's not a whole lot you can do in the meantime to force their hand, because by the time you go through the process to force them to give you the records, 60 days is over. So generally, that's one thing. Getting police reports, getting open records requests we've described in other videos, those can take weeks to months to get back. So initial documentation about your case, if it's a situation where we have decided, an immediate lawsuit may not be necessary, this is potentially a case that we just settle with the insurance company without having to go through the formal litigation trial process. That initial investigation is going to be kind of the first block of time where a case goes.
Right. The next, I think, largest issue for us and clients, when they ask me up front, I say, well, how long is this going to take? And I say, well, it depends on your treatment. If you recover in 12 weeks, when you notify us that you've completed treatment, then that starts the timer on us sending out medical records requests, and then receiving those could be 30, 60 days you discussed earlier. But there could be other issues if you have to treat for a year. I know in big truck cases and auto cases, we've had it too, where you have a traumatic brain injury. Oftentimes, doctors will say that, well, we got to see how you are in a year. If you're still having deficits and problems, then we believe this is probably a permanent issue. Or if it resolves, then it's not. So there's not a lot of things you can do as far as physical treatment for a brain injury. There are medications and some other exercises that they'd like to do, but it's not like you're going in and doing some sort of chiropractic treatment or PT on your back or something.
Yeah. I mean, there's some injuries that people get into and they either have, a quick surgery and make a large recovery, or they do some conservative treatment for 8 to 12 weeks. and are largely back to normal at that point. Those cases, the treatment doesn't go very fast, doesn't take very long. And the reason why, treatment dictates the time frame is because ultimately you don't want to settle your case, whether it's through the formal process or the informal process, until you know that you're as good as you're going to get from your medical treatment. Some injuries are permanent, and so you'll never get back to 100%, but you still want to know just how good you're going to get back. And you got to exhaust all your options. You've got to, if surgery is recommended, you may have to have that surgery, or at least talk to your doctor about alternatives if you don't want to have that. You have to see how you'd react to long-term treatment plans, things like that. And the reason that you don't want to settle your case before your treatment's done is because you cannot go back once you decided to settle.
Right.
It's
final.
It's a big misconception that we get, that you can get some money up front from this insurance company to pay for your immediate medical bills. And we're talking about, the at-fault party's insurance company, not other forms of insurance we talked about previously. But the at-fault party is only responsible for making one payment. And so you really want to make sure that that payment encompasses everything. We had a client recently who, thought he was not hurt very bad after the initial car wreck. And a couple weeks later, he started having back pain, ended up, having a permanent nerve injury that we were able to get significant compensation for after a few years of treatment and determining what that was going to be. But he was prepared to take a very small payout shortly after that wreck just to get the process done. Thankfully, he called us. We convinced him to go through the process, and he was ultimately able to get a much, much larger, fair settlement for the nature of his injury.
Yeah, it's hard to get a full and fair settlement if you don't know the full extent of your condition. So we don't want to jump ahead of ourselves there.
So treatment, can dictate how long it takes to settle the case, because if you're able to finish that treatment within a matter of months, we can start the process of trying to get the case finalized after those couple of months. If your treatment takes, years to determine permanency or, get you back to 100%, then, we can't finalize the case until that's done. But we can be doing other things in the meantime.
Yeah. Well, normally when that comes up, and you may hear your attorney, you could hear your doctor talk about this is the fork in the road. It's either you've recovered, or at some point the doctor's going to say that you've reached MMI, or maximum medical improvement. And what that means is that no additional care is going to make you any better than what you are at this moment. And now it's just a matter of maintenance, potentially, I guess, as far as treatment. So the reason why we don't go ahead and start the process of wrapping your claim up once you've reached MMI necessarily is because now we have to request either from the doctor or another qualified practitioner to let us know what's your prognosis going to be. Are you going to need a future surgery? Are there going to be future medicals associated with these, whatever the condition is? Maybe jump into that.
Yeah. So, you can't really know what your ultimate medical outcome is going to be until you get to that point. Some people will need ongoing future care, and that's something that a doctor and potentially other providers can give you an estimated cost for that would have to be compensated going forward. So, just because you have a permanent injury doesn't mean you have to wait till the end of your life to be able to settle this claim. But you do have to wait to a point where the damage to you and the injury is reasonably calculated what it can be even into the future. So once we get to that point, then we can start negotiation with the insurance company or the at-fault party who's responsible for paying you. And like we said, in the meantime, we've been sending out those investigation documents. So hopefully by this point, the liability information's come back, the, police report, all of that other information that we need to establish the other party is at fault. Once you get to the end of this medical treatment, we gathered the medical records, which takes a little bit of time. We've determined any future care that you may need. We kind of wrap that up with a little bow, send it in to the insurance company and say, this is what the claim's worth. You need to pay it. And if the insurance company agrees, your claim wraps up and able to reach a settlement and it ends right there. Unfortunately, is not always the case.
And there can be multiple places of disagreement. For example, oftentimes, I don't think people understand this, but the insurance company can agree that they're at fault, but they disagree about either the damages that result or maybe just the scope of the damages, the amount, what maybe future treatment, all that sort of stuff.
Yeah, I would say that's actually the biggest disagreement that usually happens in these cases. Clients will often come to us and think, I only need an attorney if the other side is denying liability. And while that may be true sometimes, the biggest place that insurance companies dig in on these injury claims is they say it's just not worth as much as you think it is. Oftentimes, liability is conceded, or liability is reasonably clear that as soon as you call an attorney, the insurance company, gives up and says, we'll pay you what a reasonable payment is, but we think reasonable payment is $1,000 and you think it's $100,000. And so we're not going to pay you what you think is fair.
Right. So before we get to that situation where they're making an offer to settle, let's talk about the negotiation process, maybe the time frame for that.
Yeah, so if you get to the end, let's assume that this is the case that we don't think that we would have to file a lawsuit on. We think we can get it filed, we can get it settled just with the insurance company through the informal claim process. After you finish treatment, or after you get to a point where your treatment is reasonably certain, it takes, somewhere between 30 and 90 days to get those medical records. Takes about 30 days to put that package together in the insurance company, and it takes them about 30 days to respond with an initial offer. And like we said, that initial offer comes in, and they say, hey, we agree, or we don't have enough insurance to pay as much as you're asking, but we'll give you the entire amount of the insurance that we have. And the client accepts that offer. We can get the case settled. Then, that negotiation process can be as short as a week, once all that's done. But, there are some negotiations which are more fluid. We still get them done with the informal process, but that negotiation can take, up to 30, 60 days.
Right.
Going back and forth a few times, making a few points, sending them additional documentation sometimes they've asked for. So, yeah, I would say, by once you get to about 60 days in the negotiation process, you have a pretty good idea if you're going to be able to settle that claim or if you're going to have to file a lawsuit, even if it's a claim that you thought you may be able to get settled, through that informal process.
And another consideration to keep in mind is, and you kind of alluded to it, let's say the insurance company for the at-fault driver or trucking company goes ahead and tenders their policy limit. If the client, if you have what's called underinsured motorist coverage, there's certain statutory time frames that you have to abide by in order to have access to those benefits. Let's describe that.
Well, not only that, but to get underinsurance benefits, if the liability party does not have enough insurance, which we've talked about in previous videos. There's a whole process for that too that you have to go through before you accept the liability offer. You have to put the UIM carrier on notice, make sure that you've given them fair notice. It's a very easy thing to mess up if you haven't done it before. And if you do that, you can void your entire UIM coverage. So it's very important that you get that correct. That process takes 30 to 45 days to get done.
Right.
And so again, everything that we've described so far is kind of the informal claim settlement process. It's just calling insurance up, giving them the information they need to settle the claim, and making sure that's done. If that fails, or if there are certain cases that we just know right away, it's not going to be a case where that informal process is going to be successful. At either one of those 2 points, we would have to go through the formal process, filing a lawsuit.
Right.
And then that becomes a whole nother issue of timing. And
Let's dive into that.
Yeah.
If you're in a situation where insurance company, Acme Insurance, has either denied your claim or they're offering something significantly lower than your client is entitled to, and you decide you're going to file suit today, what's the next thing there? What do you have to worry about time-wise?
So
Considerations, I should say, time-wise.
Once you decide to file a lawsuit, it takes a short period of time to draft that lawsuit and get it filed. For a normal personal injury case, we would have that information when we're ready to file a lawsuit. We can get that out the door pretty quickly. The next thing that has to happen is that every other party in that lawsuit, so, the at-fault party, any associated insurance companies that need to be in the lawsuit, any corporate entities, each one of those has to receive what's called service, which essentially in layman's terms is official notice of the lawsuit. Sometimes you can accomplish that through a certified mailing process, especially your companies. Sometimes you have to hire a processor or a sheriff to go hand them the lawsuit directly. And in either one of those cases, at minimum, it's a few weeks turnaround for that service, whether it's through mail or, through sheriff process. In some cases, that can extend to several months. We just had one where, we could not find a guy for a period of time. We ultimately had to hire a private investigator, and after about 7 months, we found him. So, that service process can be a little bit unpredictable.
And people dodge.
Some people dodge.
Yeah, they'll keep their blinds tight and leave at different parts of the day, avoid...
That's rare, but it does happen.
Right.
And then, after a party is served, they have 20 days to file what's called the initial answer. That period doesn't take very long, the 20 days. The answer usually comes in on time during that process because there can be severe consequences if it doesn't. But then immediately after they answer, and what they generally say is they just deny everything in the lawsuit. We're not responsible.
Right.
Prove it, which you kind of already knew when you were filing the lawsuit anyways. They were going to take that tack. The next thing is what's called discovery, and we've described that in detail in another video. But
we'll link to that later on in this video at the end.
Yeah, absolutely. And so, the discovery process itself, that is the period that takes the longest amount of time. And it can take anywhere between 6 months and several years, depending on
complexity of the case.
Yeah, that's one issue. Sometimes, again, like we said, the lawsuit gets filed while the client's still treating. So we have to wait, for that treatment timeline to happen while the lawsuit has already been filed. Sometimes the lawsuit gets filed after the treatment is complete, so that process can go a little bit quicker. Some cases are complicated, some cases are simple. So that can all affect the discovery process. But generally, to do all of the steps in discovery properly, at minimum, I would say about 6 months is reasonable.
Yeah. Let's assume that you've gotten through most of the discovery phase. Now there's a situation in which the parties have an opportunity to make certain motions to try to dispose of the case one way or the other. Discuss that and some of the time considerations associated with that.
Yeah, so there is a legal process where if the facts of the case are not in dispute, and one side thinks, hey, the facts are clear, legally you don't have a case anymore, they can ask the court at that point to dismiss the case. So this is not something that comes up in a car wreck, like let's say where each party says they have the green light. That is a factual issue. And the only person that can determine the factual issues of the case is a jury. Judge can't decide those for you, no matter how clear they are. But, if both sides agree, or if there is just no competing evidence from one side that a fact is true, and if that fact, means one side wins the case, a judge can step in at that point and dismiss the case. So defendants use this tactic much more often than plaintiffs. It's just a consequence of how these cases work. It's not that plaintiffs' attorneys are lazy. It's just this tool is not usually available to them. But that can significantly delay the case, especially in state court where judges are just overwhelmed with caseloads. And in some cases, it can just be a delay tactic. And in certain cases, depending on the complexity of the case, depending on the complexity of that motion, to dismiss the case at that point, those can take several months. I've seen certain cases take years to have those motions resolved.
Right.
And there's nothing you can do about that to speed it up.
No, it's a two-edged sword because if you poke a judge to get an answer, sometimes they'll give you an answer quickly that you don't like. So you gotta be careful there.
Well, I will disagree slightly there because there is no poking the judge. You just don't do it. And there are good judges that know they owe you stuff and they're working on it as quick as possible. There are some judges that they like to take their time, and it doesn't matter who you get. Even if you get one of those second ones, that's something you have to roll with. It's part of the process. And defense attorneys know who those are. They know the delays they can get in certain cases. It's an unfortunate part of the system, but it is a part that you have to deal with.
So another time consideration to keep in mind that in some cases can add significant time to this is we've got the case built out. We've got all the information we need. We've got all the doctor depositions in the can. Everybody's been deposed. We've had the motions that were made. But oftentimes, I think the parties want to do it, but oftentimes judges require it as mediation. And I don't think that most people realize that there's good mediators out there. There's bad mediators, just like there's good doctors, good lawyers, bad doctors, or bad lawyers. And shockingly, the good mediators are 6 months out just to get a date on their calendar.
Right. And mediation is basically just a chance to settle the case with a neutral party, kind of prodding each side to say, hey, your case is not as good as you think. You should come meet in the middle. And that is one place that a good attorney with forward-looking ideas can save you a lot of time, because if you know that you want to use a certain mediator and that mediator's calendar is 4 to 6 months out, you can go ahead and contact the other attorney, be a little bit proactive and say, look, we're going to be ready for mediation in 6 months. Let's schedule it now so we don't have to wait on that person. A properly scheduled and properly used mediation should not significantly delay the case. There's always exceptions. There's unexpected times where you may need mediation that you weren't banking on. You still want to use one of those guys that's a few months out. There's cases where the other side just won't agree and a judge won't hold their feet to the fire. Right. There are times, but we do everything that we can, and good lawyers will do everything they can to not let the mediation process add to an already lengthy process to get these claims settled sometimes.
Right. Those are all good points. Assuming that you've had the mediation was not fruitful, now it's time to move to trial. That's the only thing left at this point in order to prove your claims and get compensation is a trial. If you're going to file a motion to get a trial date today, I know that every county is a little bit different, but in state court and federal court, it's a little different. If you filed today and we're in October 2025, with your experience, how far out are you before you can even get a trial date?
Well, you're really bringing me full circle here because it depends.
Yes.
Yeah, we're right back to the beginning, and if there's anything I want you to take away from this, it's just all of these things are flexible, and they all depend on the case. They all depend on the judge, the jurisdiction.
All right.
But a few little areas I can give. There are certain judges that will not give you a trial date until you've completed every step that you need to get to trial. Very stubborn. I don't necessarily like judges that have that system. I don't think it's the best system, but I don't get the judge is the one that dictates the rules, and they have a lot of discretion here on how to do it. Those judges, once you've done all of these steps and you've taken the months and the years to go through them, they can generally give you a trial date within 3 to 6 months. Which again, that at that point, it just seems like an agonizingly long period of time because you haven't gotten on the schedule yet. There are other judges, especially in state court, that you can ask for a trial date once you have done a significant amount of work on the case and both parties kind of agree that the case is going towards trial. Judges that use that system will have a lot more trial dates on their calendar because they schedule them earlier in the cases. And so judges that use that system, those trial dates can be scheduled anywhere from 6 months to 24 months out. I've seen almost 2 years to wait for a trial date in certain counties on certain cases. And that's not necessarily the judge's fault. It's just the way things fall. Scheduling issues are beyond a lot of people's control in this situation. But it's important to know, like we said about mediation, who your mediator is going to be where you are in the case. If you know you're in a county that's 2 years out from trial, you need to be asking for that trial date when you're 2 years out on your schedule from having all the stuff done ready. If you know that they're 6 to 8 months out, you need to be thinking 6 to 8 months ahead, getting that trial date and setting some deadlines about doing those things to get that trial date as soon as you can.
And that can be helpful when you get the insurance defense firm or lawyer that likes to drag their feet, that is withholding stuff, because now they're on the conveyor belt. There's certain timelines and dates they have to meet, and it kind of gets them moving.
Sure. And this isn't really the purpose of this video, but I do think it's important to mention. We'll probably cover it in more detail later, but there's several places where it's possible to get full value for your case. The informal claim process and a claim that's obvious or that has lower insurance limits, that is a place where you get full value for your case on something like that. Relatively quickly after you file a lawsuit, if the insurance company says you're going to have to make us pay, and when you file a lawsuit and they say, we didn't think you'd do that, that doesn't happen very often, but every once in a while, that's an opportunity to get full value. Mediation is an opportunity to get full value. Sometimes lawyers with good reputations and strong cases after the close of discovery without mediation is a chance to get full value. But in a lot of cases, the only time where you will get absolute full value, especially if the claim is open-ended, is the week or the day even before trial. And so it is important that you build the case, that you schedule the trial date, that you get what you need to go to trial, that you do that work, because that is often one of the best chances to get full value on a case. And if you're not prepared to go all the way to trial, or you don't do a good job preparing the case, or if they can tell that trial is not important to your firm or you personally, they will use that as an opportunity to squeeze the value down.
Yeah, agreed. And another little dirty little secret that most people never talk about, that I bet that you don't know, is that when judges schedule trial dates, oftentimes they're scheduling 2, if not 3 cases to go to trial on a specific date. And you may be asking yourself, well, that's crazy. How are they going to try 3 cases in one courtroom? And maybe you can describe...
the answer to that is that they won't.
Right.
Generally, the oldest case on the docket gets priority. And like I said,
the younger case, the newer case will get bumped.
Yeah, so, the reason the judges do that is because if they use that process of scheduling trial dates, 12 to 24 months out, they want to make sure that that date is getting used. And they know that most cases will settle at some point during that process, whether it's early or late. And if it's late, they may not be able to backfill another case. And so, I've had situations, every good trial attorney has had situations where you're what's called double booked. And you are then trying to communicate with that other person who has the trial, especially if they're in front of you, to say, hey, are you going to settle your case? Do I need to be ready for this? And of course, you always have to be ready.
Right.
But we actually had a situation last year, another attorney that I have a lot of respect for. We were double booked with him, and he's famous for, just trying every case. And he was behind us. And he was calling us every single day for a month, being like, have you settled yet? Have you settled yet? Because he wanted to try his case. He was ready to try his case. And I'd tell him.
I don't blame you.
Yeah, sure.
Put a lot of work into it.
I would have done the same thing if I was him. But I had to keep telling him, I'm like, look, we made a very reasonable offer and they won't take it. We're going to have to try our case. Right. And he was, very disappointed that we stole his trial date.
Right. The settlements do happen on the day of trial, the day before trial.
Sometimes during trial.
And yes, during trial. I've seen that happen before. It happened in our office. Matt had settled his case after putting on his case in chief during the middle of the trial.
Great sign of respect.
Yeah, it is. I remember that specifically, the judge asked both counsel to come back to his chambers and said, hey, you really should try to get this settled, because it was not going well for defense on that particular case.
We'll have to tell that story another time, because right. I'm sure ultimately, the people who've stuck with us this long, they kind of want to know
right
what this all means for them as far as total timeline.
To wrap that up, so if you get bumped, you're looking at, depends on the judge, but it can be another 3-4 months, oftentimes, before you get on. They'll try to move cases that have been bumped into earlier dates if possible. Yeah. That's not always the case.
It's hard to predict.
Right.
It depends on their calendar.
And I know that people, and I think Matt is correct on this. I think it's still roughly the case. On average, people used to ask me like, well, when am I going to have my trial on this? And from the date in which we filed the suit, I think a good rule of thumb is probably 2 years. Some cases go longer, some can go shorter, but I think 2 years is probably a fairly efficient time frame that you could expect if all things are going well.
Yeah, if there's no medical delays during the lawsuit, things like that, a reasonable amount of time to expect a lawsuit to last is somewhere around 2 years, maybe a little bit shorter. We've discussed all the reasons with you already today that could change, and there could be decisions on not filing the lawsuit right away. You have up to 2 years from the last date of PIP payment to file a motor vehicle claim in Kentucky. You have 1 year from the date of injury on non-motor vehicle wrecks to file a lawsuit in Kentucky. And a lot of attorneys will wait till that last day. We don't always do that, but it's not uncommon that, they will take all of that time.
Yeah, no, that's true. Getting to the end of this video, I do want to hit just a couple things that I don't think that happens often, but it is something that I think somebody should consider, but it's the appeal process. You can go and you get your judgment in front of a judge, or maybe you've lost one or the other. What's next? And clearly, in some cases, appeals are available, recommended. Some cases they're not, and you don't have any appealable issues. But assuming you do have an appealable issue, what next?
Federal court generally adds 8 to 12 months, and then if it overturns, it gets kicked back to the trial court. You're right back to the same position in the case you were before. State court, it can take anywhere from 1 to 2 years at the first level, and then the second level can add another 2 years. There are cases in the system that are still active that The injuries occurred in 2010, and it's 2025 right now. Those cases are the very much exception to the rule. Your case should not take 15 years, but there are cases that do. And, we'll just have to get into that another time on why those things happen, but it can be multiple appeals, complicating treatment factors, those kind of issues.
All right. Well, if you got any other questions, please leave those in the comments below. We do look at that, and we'll make another video of that if we think that it's a good topic to cover. If you want more information on the lawsuits, how long they take, discovery process, or any part of personal injury subject matter, go visit our website at steinwhatley.com. You have anything else?
No, I think that covers it.
All right. Thank you, guys. John Whatley with Stein Whatley Astorino, Serious Attorneys, Serious Results.